Good morning, everybody, and welcome to the First District Court of Appeals. We have two cases set for argument today. When I call your case, would the person arguing the case please stand up, state your name, and tell me your readiness to proceed. The first case today is C-23-0175, Fiani versus WorldPay, LLC.
John Allison on behalf of the appellant, ready to proceed.
And Emily Gelhaus on behalf of WorldPay, the appellee, ready to proceed.
Thank you. And our second case today is C-23-0272, Cross Acquisition Company, LLC versus Groundworks Ohio, LLC.
Good morning, Your Honor. Thomas Yoakum for the appellant Cross Acquisition Company, LLC, ready to proceed.
Good morning, Your Honor. Sarah Negus on behalf of the appellee, Lana Key. We're ready to proceed.
Thank you very much. The first case, Fiani versus WorldPay, if you would come on up. Mr. Allison, whenever you're ready,
Thank you, Judge.
would you like to reserve any time?
3 minutes, please.
Okay.
All right.
Give me 1 second, please. I'm new at this, so. Okay. I'll start your time when you're ready.
Thank you, Judge. There's a couple of issues here. The appellant claims that the trial court committed error by not allowing the appellant to amend the complaint to add a gender discrimination claim. And then there's also the error that the appellant claims that the trial judge did not, or overruled Mr. Fiani's objection and allowed the defendant at the time, appellee, to waive the attorney-client privilege well after discovery but before trial, and then present evidence consistent with that. And I'll start with the motion to amend first. Under Rule 15, it's a liberal amendment policy. When justice so requires, the idea is cases should be decided on the merits, and when a judge does not give a rationale for denying the motion to amend, that's abuse of discretion. This appellate court has considered a number of factors: timeliness, good faith, whether there's prejudice to the defendant, and then whether the amendment is futile. In this case, there's no argument, I don't think, that there was bad faith, so I'll skip over that. In terms of timeliness, the amendment...
Are you equating futility and bad faith?
No.
Okay, all right.
I am not.
All right, so bad faith,
Thank
you're
you,
putting
Judge.
aside, but, okay,
Yes, I am not.
okay.
In terms of timeliness, it's true that the motion to amend was filed, well after the complaint was filed. The complaint was filed in May of 2019, and the motion to amend was September of 2020. But COVID happened, there were some delays, and the reality is in plaintiff's employment cases or employment cases, depositions are sort of where it's at. That's where you discover your case. And all of the defense depositions, or at least from the first 5, were taken in August of 2020. And
Counsel, what did you learn in those depositions that was new with regard to the promotion situation? I mean, certainly Mr. Fiani knew that these other 2 women had been hired in place of him in this position. So what was it that came out in the depositions that was new?
yeah, I think primarily, the primary fact I would say is that Fiani wasn't even considered for that second role. And we thought that was very significant. And candidly, I think going through the depositions and the evidence sort of crystallizes for the attorneys, we realized we should have a gender claim here. You're trying to, you could pick every category. Mr. Fiani was different from Ms. Wilmot in terms of every category: age, national origin, race, gender, but you're trying to figure out what your best evidence is. And I think in those depositions, it really crystallized for the attorneys that there is a gender claim here, we should have that.
And can you help me understand how the promotion situation ultimately translates to a gender termination claim?
Yes. So there's a sequence of events. So Mr. Fiani is passed over the first time, he's not selected the first time, and Ms. Wilmot, who's completely unqualified, is selected to be the procurement officer going forward. That's in the spring of 18, April of 18, I think.
Oh, wait a minute, wasn't Ms. Wilmot the procurement officer for the UK company?
She had been put into that position just 2 months prior to the merger. She had actually been in IT, I think, and their chief procurement officer left, and they put her in a temporary spot. And she admitted to Mr. Fiani that she wasn't qualified, and when she got the role, she resigned. She had only been in the procurement role for a couple of months prior to the merger, and then in early 2018, she resigned. And I don't, well, that's my answer to that, Your Honor. So there's a series of events. So he's passed over in favor of Ms. Wilmot, who's completely unqualified, and then a few months later, when WorldPay is trying to figure out what to do with the position, this is in the summer of 2018, they decide we're going to have it's going to be a global role, and they go out and they select Ms. Fielding. But Mr. Fiani, prior to his time with Vantiv is the company that merged with WorldPay, Mr. Fiani had global experience, and he wasn't even considered. And so he's placed in this temporary role, and then he's terminated in November. And it's that sequence of events that we believe is demonstrative of discrimination on the basis of race, national origin, and gender.
So you're saying that there was gender discrimination in not giving him the position, which ultimately led to him being in a temporary position, and because it was temporary, then he was terminated.
Yes.
So the termination, the ultimate termination was not based on gender discrimination. It was how he got into that final role.
So you're asking the big picture question, Your Honor, and we think it was.
Okay.
And what that comes down to ultimately, and there's Mr. Fiani's testimony with respect to this issue starts at page 548 of the transcript and goes a few pages. But there's this series of decisions, and he's placed in this temporary role. And our argument at trial and the briefing was that Mr. Cole was directed to terminate Mr. Fiani, and that the direction came, or the influence came from Mr. Heimbach, who there's a lot of argument in here about his discriminatory statements and all of that, and Ms. Ferris, who was working with Mr. Heimbach. And the argument that Mr. Cole was influenced was that when Mr. Fiani was terminated, just a week prior, he'd been given 2 big projects by Mr. Cole, and then all of a sudden he's being terminated. He was told that it was a reduction in force, but only one person was let go. There's testimony that the budget that was impacted by this, by Mr. Fiani staying on, was the budget that Mr. Heimbach was in control of, the integration budget, not the operational budget. The operational budget was what Mr. Cole was responsible for. And then a week or so after the termination, Mr. Cole pulled Mr. Fiani aside privately and said, look, don't blame him for any of this, pointing to Mr. Green's office. Mr. Green was Mr. Fiani's prior boss, and the implication being, don't blame him, it's somebody else. And we believe that there's, and by the way, I'm not going to make a big deal out of this because it'll sound conspiratorial, but their argument on the 6-month statute of limitations, what's interesting is that 6 months after Mr. Fiani doesn't get that first role, it's really 6 months and a few days later that he's terminated. Now, I'm not going to try to tie those together, but that is the timing.
Counsel, if we
Yes, Your
were to agree with you
Yes.
and remand this case back for a trial on the claim that's raised in the motion to amend, what does that claim look like? What is that claim?
Well, it's a gender discrimination claim, and I think that claim is very similar to the race and national origin discrimination claim in terms of the sequence of events. I think the difference is that if it was just a remand for that one claim, I'm not sure the evidence about some of the racial comments and that sort of thing that Mr. Heimbach made is relevant, at that point. But other than that, in terms of the sequence of events, it's very similar.
I'm going to try to be brief and summarize what I'm hearing the claim to be, and just tell me if I'm correct.
Yes, Your Honor.
The claim would be that Mr. Fiani was terminated because of his gender, based on evidence from your perspective that he was passed over for the procurement role in favor of two women, put into this temporary role, and then terminated. Is that accurate?
Yes, Your Honor.
Thank you.
Yes.
You've got, sorry, that just disappeared.
No,
You've got 3 minutes left.
3 minutes left. I will move quickly. So in terms of timing, I think that the motion to amend is timely because of the depositions that I spoke to earlier. In terms of prejudice to the opposing party, there wouldn't have been, the only thing that maybe they would have felt they needed to do is reopen Mr. Fiani's deposition and ask him what evidence he had with regard to gender discrimination. But the plaintiff's side would not have had to do additional discovery as a result. Our view of it was that we were amending to fit the facts that we had discovered during the process. In terms of it being futile, it's not. We added the facts and the claim and the complaint that needed to be added. The other side makes an argument that, well, it couldn't have survived a motion to dismiss or motion for judgment on the pleadings because you don't have this background evidence for a reverse claim. But we do. One of the ways to prove the background evidence is that the decision maker, Ms. Ferris in this case, is in the same minority group as the person who was selected, Ms. Fielding, and that's how we would show the background evidence. So it's not futile for that reason as well. And getting into the trial, I'll just mention this very briefly, the jury picked up on that. Even though we weren't presenting a gender discrimination claim, the jury picked up on this seems like these are gender-based decisions. There was an argument made in the appellee's brief that the question that was presented by the jury wasn't understandable. I actually said we shouldn't ask that question, not that I was confused by it, because I didn't want to confuse the jury by having a gender discrimination claim asked when there's no gender claim. Moving on to, I know I've just got a couple of minutes, I'll be quick. Moving on to the second assignment of error. During the
You have
entire,
about 30 seconds if you want to reserve
I can
your
do
time.
this in 30 seconds, Judge, thank you. During the entire 3 years, we were not permitted to get discovery on the investigation, depose Carrie Russell about, ask those questions. And then she was permitted to testify at trial and present this 20-page document that, a lawyer coming in and testifying that I did an investigation and there's no discrimination, that carries a lot of weight with the jury. And our concern is that after being prevented to discover that, from discovering that throughout the whole discovery process, that the court allowed that to come in at trial.
Didn't the judge allow that to come in because it was mentioned during opening statements?
I was actually very careful to avoid that, Judge. If you read that page, what I did was I said, because you have to tell the story. So what I said was Mr. Fiani was talking to Ms. Russell, and he said, please don't investigate. I'm afraid there will be retaliation. And then I skip over whether there was an investigation, and I say, and then he was retaliated against. I totally skipped that, and I tried to do that intentionally to tell the story without talking about there being an investigation. So I hope I navigated that well enough, but that's what I did.
Okay. And so then the other side felt it necessary at that point because it was mentioned in opening to explain the investigation? Is that what happened?
I think the other side planned on talking about the investigation all along. I think their position was it was important to be able to explain that there was this complaint made, the investigation, and they found that. I just think that was a course change that they made before trial that they had not, used in the discovery process.
Mr. Ellison, if you want to reserve time.
Thank you very much, Your Honor.
I forgot to mention this earlier, so when the yellow light means you have about a minute to go, and then the red light means that your time is up.
Thank you.
I'm sure I'll forget that.
That's okay. Whenever you're ready.
Thank you. The jury heard all the evidence in this case relating to Mr. Fiani's termination, which is the only employment issue and that is an issue in this case. And they returned a verdict in WorldPay's favor. The jury's decision and the judgment entry should be affirmed. On the first issue, the gender discrimination claim in the motion to amend had nothing to do with Fiani's termination. It was based entirely on Fiani not receiving 2 jobs that women received. As you've already discussed, these are discrete employment actions that were barred by the 6-month contractual limitation period at the time the original complaint was filed.
Well, they're arguing that this was like a chain of events that led to his termination.
And there is no continuing violation here because we have separate decision makers. Ms. Ferris made the decision about Joanna Fielding and put her in the COO job, which was a different job that Fiani had done. And she made that decision in the summer of 2018, so well before the complaint was filed in this case. So relating that back makes no difference. So she made that decision, and Royal Coal made the decision to terminate Mr. Fiani's employment. So there's no continuing violation because we have different decision makers.
And your argument that his employment was terminated for what reason then?
There was a merger, and in the merger, he was put in a job where he was merging customer contracts. And in mergers, when the merging work is done, unfortunately, people lose their job when that work dries up.
So
And
he
that's
was
what
in a
Royal Coal-
temporary position.
He was put in that position when there was work to be had. No one knew where it would end up, but it ended up being a temporary position. And Royal Coal testified about why and when he decided to terminate his employment. He gave Mr. Fiani projects. He realized there wasn't enough permanent work left. He testified about why he said, "Don't blame him," when he referred to Mr. Green. Mr. Green was his best friend, was the plaintiff's best friend. He was saying this was my decision. So the jury heard all of that, heard all of Mr. Cole's testimony, and understood his reason for why he decided to terminate him. And it had nothing to do with those promotion decisions that he was not involved in. He was in a separate line of the business entirely. So Fiani cannot get around this by arguing that these 2 jobs were somehow connected to Royal Coal when he made his decision months later.
So does this information connect to the futility piece of the test? Is that your argument?
Yes. So it's futile in a couple of ways. One, these are discrete employment actions that are barred by the contractual limitation period, so they're untimely in that respect. And then it's also futile because these are made by different decision makers, and just saying that women got jobs over me isn't enough for a man to make a claim. He has to have some evidence, something additional to say that this is the unusual employer who discriminates against the majority. And there's no evidence here.
I mean, I think that he was pointing out that if you look at the qualifications, he was much more qualified than either of the 2 women who were put in this role. How do you respond to that?
Mr. Fiani testified that the job Ms. Fielding got was an entirely different job than he had been doing. It was the COO to the CFO. It was not just procurement. Interestingly, the person who actually ended up doing procurement was a man. He was an independent contractor. So there's no gender discrimination there. The other job was Ms. Wilmot, and she got the job. It was an interim job for procurement during the merger when they were deciding who was going to end up with the job. She left the position, she left the company shortly after getting that interim job. They gave it to Mr. Fiani, and he said he no longer wanted it. He was put off by it. He wanted to go work for Mr. Cole. So there was no discrimination there either.
Thank you.
Now, there's Mr. Fiani's delay in filing his claim, waiting until a year plus after his complaint, trying to amend at that point, is another reason to deny the motion to amend.
He's claiming that he learned in depositions that he wasn't even considered for these positions. and that was new to him. I mean, obviously, he knew that he didn't get the role, and he knew who got the role because he was working there. But this idea that he was never even considered, he says is new. Can you address that?
Not being considered doesn't get him anywhere because, again, a man ended up with the independent contractor job doing the procurement. So there's no evidence of sex discrimination. So that doesn't get him anywhere either. So waiting and then claiming that that was new evidence, which, by the way, they never told the trial court what their new evidence was. In their motion and in their reply memo, they said there's new evidence, but they never identified what it was. It's only now that we hear that it was this testimony by Ms. Ferris that he wasn't considered. So there's no reason for his delay. That's another reason to deny the motion. So for all of these reasons that were briefed and considered by the trial court denied the motion, which was not an abuse of discretion. And I have to address it just because Mr. Allison brought it up. One unasked question by a juror after the first witness is not evidence that the jury thought there was gender discrimination. You can read that section of the transcript. Everyone agreed that the question was incomprehensible and it was not asked. So it's not evidence of anything. As for the second issue, Ms. Russell's investigation also had nothing to do with Fiani's termination by Royal Cole. All the evidence in the record is that Cole did not know about that investigation when he terminated Fiani's employment months later. Nonetheless, the trial court properly admitted all the evidence about the investigation after, as you noted earlier, Fiani brought it up in his opening statement.
So was that was the reason why the defense wanted to bring in information about the investigation, because he briefly mentioned that in opening?
Yes, it was going to be a centerpiece of their case, that he had complained and that WorldPay did nothing. That was going to be their argument. And we knew that based on their proposed trial exhibits. The privilege log was one of their proposed exhibits. So it wasn't that they weren't going to talk about the complaint or the investigation. Mr. Fiani talked to Ms. Russell during the investigation.
There was, I believe, mention at the trial of a letter that was sent by WorldPay to Fiani in advance of trial when WorldPay elected to waive attorney-client privilege, offering some kind of reopening, limited reopening of discovery or something. Is that letter in the record anywhere?
The letter is not. We discussed it during our amended pretrial statement that was filed on October, I believe, 24 of 2022. And that's where we laid out how we got to this point on this issue. And in that memo, which is in the record, and WorldPay was the only side to bring this up to the trial court before trial. There was a motion in limine pending months before that to exclude everything beyond the contractual limitation period as irrelevant because we had different decision makers and it was confusing and had nothing to do with the termination. On that motion in limine at the filed pretrial conference in May of 2022, the trial court told us that that was relevant, it was coming in, which meant the investigation was going to be fair game. At that point, that is why WorldPay waived privilege in August. We were responding to what the court was telling us was going to be admitted at trial. We produced all documents immediately. We offered to reopen depositions at WorldPay's expense. And then we heard nothing for 2 months from the other side.
So what was the timing? So in August, that was the point that WorldPay determined that it was going to waive privilege, correct?
That was the point at which WorldPay waived privilege. It was August 22,
Okay.
2022.
And then how much time between that and the trial?
At that point, there were 3 months before trial. The trial was continued until the end of February, so it ended up being almost 6 months.
Okay, thank you.
We heard nothing for 2 months from the other side. They said they'd get back to us promptly. We heard nothing. In October, the other side said they objected, but did not do anything with the trial court. And we immediately re-offered and told them our offer to reopen depositions at WorldPay's expense still stood. So that was still on the table for all those months.
And I believe the the status of document production is somewhat in dispute, with your side representing that all documents were turned over and the other side claiming that maybe it wasn't all or something. But at the very least, some documents were turned over such that Fiani was not completely blind about the attorney-client privilege issue. Is that right?
Correct. The entire file was turned over. The other side was able to examine Ms. Russell at length during trial. They called her in their case in chief, and we called her and they examined her on cross again in our case. We produced the entire file. Fiani never raised to the trial court that the file was incomplete. The things that they're pointing to now are testimony that was presented to the jury. That Ms. Russell, in her normal course of business, destroyed her handwritten notes at the time she was typing in her summaries. This was a year before the litigation was filed. So the jury heard all that. Nothing was withheld. And then there were conversations where notes were not taken, and the jury heard about that as well.
Were there any motions filed in the period between August and February dealing with the disclosure that was filed? Any motions to compel or anything like that?
No. And that was part of our argument and why Fiani waived that discovery dispute, if you want to call it a discovery dispute. Any dispute over the timing of our waiver and what we produced, they didn't bring to the trial court until the morning of trial. WorldPay brought it to the trial court's attention that they expected this to be a potential issue in the amended pretrial statement in October. So we were trying to alert the trial court that this might be an issue. So Fiani, not WorldPay, wanted to use the privilege as the sword in the shield. They wanted to talk about it and prevent WorldPay from responding. So WorldPay produced all the documents relating to the investigation, as I said. Fiani was not prejudiced. He didn't bring any issue to the trial court about this waiver of privilege until the morning of trial. By waiting until trial, he waived any issue relating to the discovery about this. And again, the jury heard everything and found in favor of WorldPay. So the trial court did not abuse its discretion on these two issues that had nothing to do with Fiani's termination by Royal Coal, which again is the only employment action at issue in this case. Thank you.
Thank you.
You have 3 minutes.
Thank you, Your Honor. I'm just going to go through the points that I heard. In terms of it being separate decision makers, we would dispute that. From plaintiff's appellant's perspective, a lot of this was driven by Heimbach and Ferris, and that's what I talked about earlier in terms of the sequence of events.
Is there any evidence of that? I mean, I know that there was testimony about Mr. Heimbach and some of the things that he said, but is there evidence that he influenced the final employment decision?
Beyond what I said earlier in terms of the suspiciousness of it, the only thing I would add is that Ned Green, who was general counsel at the time, testified that in terms of him wanting to make the decision to put Mr. Fiani in the role that Wilmot got, he did not do that because Mr. Heimbach did not want him to do that. And Mr. Green testified that if it was up to him, Mr. Fiani would still be in the role going forward through the Wilmot decision, the Fielding decision, and the end. And, if Heimbach is influencing Ned Green to that extent, even though Mr. Cole doesn't admit it, nobody admitted it.
Okay, thank you.
Thank you, Your Honor. In terms of the 6-month statute of limitation argument, I would just point out that in the beginning pages of the appellee's brief to this court, they say that there are no errors in the record, so I'm not sure that they can make the 6-month argument at this stage, but either way, I think it falls apart for all of the reasons that I've talked about earlier. In terms of the waiver issue, It's on the record that we objected at trial to the attorney-client privilege being waived that late in the game. I don't think we need to do more than that. We cited a rule that allowed us to do that. In terms of us not telling the trial court there was new evidence, we specifically say in our motion to amend that we learned new evidence through these depositions, and then the new evidence is what we put in our complaint. In terms of Mr. Fiani, in terms of it being a different job, I would just say very quickly, Mr. Fiani did not say it was an entirely different job. It was a global job rather than a non-global job, and he had the experience to do that in a prior life, not with Vantive, but with a prior company.
You have about 15 seconds to wrap up.
15 seconds. He never said he didn't want any of these jobs. He said, I'm concerned that I don't have a role going forward if Heimbach's going to influence everything because he's already been discriminating against me. Thank you, Your Honor.
Thank you.
Thank you all. Appreciate it.
Thank you for your arguments. We'll issue a timely decision. Okay, we have Cross Acquisition versus Groundworks Ohio. Mr. Yocum, whenever you are ready, you can come on up. Yeah, take your time.
Please, the court, counsel. Thomas Yocum for the appellant, Cross Acquisition Company, LLC. We are here today on appeal from a decision of the trial court granting summary judgment of the defendant and Roger Keefe and denying the motion for summary judgment of Cross Acquisition. The case arises out of an employment relationship. Mr. Keefe was an employee of Cross for about 10 years, and midway through that employment, he entered into a confidentiality and non-competition agreement, which in that confidentiality and non-competition agreement, it recited that items such as customer lists and pricing information and so forth were confidential and not to be used or disclosed by the employee except in the context of employment with Cross. The agreement also provided that the employee was prohibited from entering into, after leaving Cross, entering into employment with a competitor essentially for 2 years. In other words, cannot compete or solicit customers of Cross for 2 years. So in
The geography was all of Ohio?
the company operates under the trade name Basement Doctor at the time, and Basement Doctor did business in Ohio. The agreement recites all of Ohio. The territory
Kentucky,
where,
right?
I'm sorry?
In Kentucky?
Yeah, and Kentucky, it says, and Cross was doing business in northern Kentucky and central Kentucky and in southern Ohio, essentially. And Mr. Keefe, as far as his personal activity, was primarily in the greater Cincinnati area, including Ohio, northern Kentucky, and even southeast Indiana also.
So it sounds like you all agree that the agreement is basically unreasonable, at least with geography, right?
Yeah, I agree with that statement, Your Honor. It is overly broad geographically. And in recognizing that, we introduced into the record information that defined exactly the counties where both Cross was operating and where Mr. Keefe had done business for Cross, and Mr. Keefe acknowledged in answers to interrogatories, which are in the record, those counties in which he did business for Cross.
But the issue here on appeal, because you all have admitted that the agreement as written was overly broad, right?
It is overly
You're
broad.
arguing that the judge abused his discretion in not rewriting this agreement.
We are arguing on that point, Your Honor, that under the leading Ohio Supreme Court case of Raymond, the trial court is required to modify and enforce the agreement.
What should it be modified to? What are the terms that you're asking for?
That was the purpose of introducing into the record the information regarding geographic territory that I just described.
What about the length of the agreement? Isn't there evidence in the record that, I think it's Mr. Miller, the CEO, testified in his deposition that it could be 18 months, it could be 12 months? He was kind of flexible on the term.
Yeah, well, the agreement provides 2 years, and there is a question of fact. You are right. What is a reasonable length? Is it 1 year or something more or less? That was a question of fact. The really key point here is under Raymond that the trial court was required to engage in an analysis. Could it reform this agreement based on the evidence that was in the record or at least there was a question of fact whether at trial the agreement could be reformed to be enforceable.
Wait, who would reform? It's the trial court that reforms the agreement, right?
That is correct.
Okay. So you're saying that the judge would have to make a determination of the length of time that would be appropriate?
And
Not a
yes.
jury?
Well, there was not a jury demand in this case.
Okay. So the judge, what did you all say was appropriate length of time? I mean, it sounds like, based on my reading of the transcript, you all admitted that 2 years, I mean, case law seems to suggest that's too long, right? So what did you all suggest to the judge?
Well, there was never a definitive position taken at the deposition of Bobby Miles, the president of Cross. I mean, he was asked that question, and his testimony was going back and forth a little bit, but basically he was saying around a year that he thought that was appropriate.
Well, at this point, it's been not quite 2 years, correct?
That's correct, yeah.
So it's been past that year point. Or what are we to do with that, since the time has already passed?
Correct. Of course, there are two remedies in the case. One is injunctive and one is damages. You are correct. We are at a point now where the injunctive relief is becoming moot. And so if it's determined that 1 year was the reasonable length that the agreement should be enforced, then the damages would be recoverable for 1 year of violation of the agreement. And, you all are focusing in on exactly the key issue in the case, and that is, under the leading Ohio Supreme Court case, Raymond, was the trial court required to gauge in this analysis that we're discussing, could the agreement be reformed geographically and in the length of time? And the point is, the trial court did not engage in that analysis. I mean, this is a case of abuse of discretion because the trial court did not exercise its discretion at all.
I don't think that case, Ramon case, requires the trial court to engage in a certain analysis and put it pen to paper. It just says that the trial court has the discretion to modify the agreement. Right?
Well, no, I disagree completely with that, Your Honor. And this is a key point because the Raymond decision, and we addressed this at length in our briefing, at the time it was decided, the syllabus rule was in effect in Ohio, and the syllabus rule says that the syllabus of the case is the controlling authority or is the decision holding of the case. And that syllabus, number one, which we've cited a couple times in our briefing, uses the word will. The trial court will. And there's dicta out there in different cases saying that there's discretion, but it's not discretion whether the trial court will, the trial court will do
The
it
trial court has to rewrite the contract, is what you're saying.
if the evidence is presented in the record, as we did, that enables the trial court to do that.
And that evidence you're telling us is, I'm sorry, I called him Mr. Miller, Mr. Miles. Is Mr. Miles' deposition where he sets forth that it could be 18 months, it could be 12 months, and he describes the time period that the company could live with?
That, as far as the length of it, that's correct, yes.
And then the county list would be what we would look to as the source for the
Now-
geographic term.
There's maps and county listings detailed in the record. And on the point of length, it's not just the testimony of Mr. Miles, it's what is customary in the industry. Also, we introduced into the record that the company that Mr. Keefe went to work for, Groundworks, required him to enter into almost the identical same agreement that said he would not go to work for a competitor for 1 year, is what his agreement says, 1 year. And he was asked about that at his deposition, and he said, yeah, he signed it, he agreed to it, and basically acknowledged that that was reasonable.
Can you address the trade secrets claim? I know we have some questions as to the factual basis of that. What exactly is Cross claiming were the trade secrets that Keefe took?
Well, Mr. Keefe admitted that he downloaded, before he left, hundreds of confidential proposals of the basement doctor, Cross files, proposals, customer names, addresses, pricing information, proposals that were not only clients that Mr. Keefe had worked with, but other customers in the company that Mr. Keefe had never had contact with. Those were downloaded onto a flash drive, and 3 days before he left employment, and he walked out the door with them. Now, Cross maintains that's about as flagrant a violation of, taking misappropriation of confidential information as there can be. I mean, Mr. Keefe signed the confidentiality agreement acknowledging that precisely that type of information was confidential and trade secrets, the customer list and pricing information.
Is this a customer list? Is this the information that's in the I-360, or are the proposals something different? Like, were the proposals the things that were handed to the customers? Do you understand my question?
Yeah, well, both. It was all that information. He took actual proposals and went to existing customers of Cross just after he left employment, and where he had made, for example, we have in the record Mr. and Mrs. Brumall and Mrs. Trout, where Mr. Keefe had made proposals to them, took those proposals with him to Groundworks, and went to those same customers, presented proposals for the same work.
And that was from their proposals?
Yes, from the proposals. And we have in the record, in affidavit form, answers to discovery and affidavit, itemization of damages, lost jobs, lost projects, lost money, and the trial court judge said no damages. Now, clearly, there was...
Mr. Yocum, if you would like to reserve time, you have about 15 seconds to wrap up.
I'm sorry, Your Honor, how much time?
You're at about 12 minutes right now.
Oh, okay. If you give me one more minute, I'll
You got
reserve 2 minutes then. And on the damages point, Your Honor, there, of course, it's actual damages, and the agreement provides for liquidated damages. And I noticed in...
Well, doesn't the agreement say that the liquidated damages are in lieu of actual damages, such that it would be one or the other?
That's correct. So you have a question whether you have an enforceable liquidated damages provision, or are you going by actual damages? We had proof of actual damages, and I noticed in reviewing our briefing that we did not include a couple citations that were in the trial court briefing. We cited as well-established long line of authority in the First District Court of Appeals that is not necessary to prove actual damages to recover liquidated damages. A couple of the leading cases in Hamilton County Court of Appeals on that is Physicians Anesthesia Service, Inc. versus Burt. That's First District Court of Appeals number C060761. That was 2007 case, Ohio 6871. And that case cites a case from 2003, which I was personally involved in, the Security Fence Group Incorporated versus City of Cincinnati.
Mr. Yocum, you're at over 13 minutes at this point.
Okay, I can finish the citation
Okay,
when I do
thank
my
you.
last 2 minutes. All right, thank you, Your Honor.
Ms. Negus, whenever you're ready.
May it please the court. Okay, I think Your Honors touched on a lot of the key facts here, so I won't go into a lot of detail. I do want to talk about just a few points on Mr. Keefe's agreement that Mr. Yocum conceded. He signed this agreement after years of working for Cross without any agreement in place. This agreement is admittedly overbroad as to geographic scope. We just heard that. It's admittedly overbroad as to temporal scope. But something that we didn't just talk about is the fact that the activity restrictions are also overbroad. It restricts Mr. Keefe for 2 years from working in 2 states for any company that even indirectly is related to this industry in any role.
What exactly does that mean? I know your brief references like cutting lawns. Can you help
Sure.
me understand this indirect?
Yes, I think that the fact that indirectly isn't defined is the issue because it doesn't give Mr. Keefe a clear understanding of what he is prohibited from doing, which is an indication that the agreement's unreasonable. So, for example, it prohibits him, we gave several examples in our brief, but it's being employed directly or indirectly in the industry. So that's the issue. It extends the scope of the activity restriction when it references indirect activity and indirect employment, because that loops in other companies that aren't directly in the business or the basement restoration, crawl space, repair industries. So that's another indication of the overbreadth.
Would you agree that our case law requires a trial court to modify an agreement if it is easily modifiable?
I don't think the case law says exactly that. I think we go into great detail about the Raymond case and the syllabus rule and all of that. But courts certainly have the discretion, and most courts, when they're citing to Raymond, cite the courts are empowered to reform to the extent that reformation would serve a legitimate business interest. So I think finding that it's mandatory to reform these agreements would have very broad-reaching effects here. So no, I don't think it is required that the court modify the agreement.
Because it seems to me that the temporal piece of it is easy to modify, just to knock it down to a year, and the geographical piece would be pretty easy to modify.
Yes and no. I think technically it probably could be easy to just strike 2 and write in 1 year, but Ohio courts have found that there still needs to be some sort of a tie to a legitimate business interest to justify the 1-year limitation. So I think the court would have to do some work to look in the record and see if that's justified in this circumstance. Same with the geographic scope. There is information in the record showing the counties, and I think it's less than half of the states of Ohio and Kentucky that Cross as a business did work in. Even fewer of those Mr. Keefe performed services in.
And counsel, to that point, what do we do with the fact that Keefe apparently made sales in Indiana, and Indiana is completely excluded from this agreement entirely?
It's an interesting point, and I think it just goes to show that Cross is asking the court to do a lot of work here. Is asking them to analyze, should it be this scope that Cross performed services? They had 15 other inspectors, sales inspectors, that did the same work as Mr. Keefe, and they didn't have assigned territories. So is it Cross's territory? Is it Keefe's territory? And how far back do you look? Do you look in the past? He's worked there for 10 years. Do you look all of his sales history in 10 years to determine the scope? Do you just go back 2 years? Do you go back 1 year? That's something that the court would have to decide if they're following Cross's recommendation to rewrite this agreement.
If we are looking at this on an abusive discretion basis, let's just say theoretically, we're looking, if we do look at it that way, what do we do with the evidence that Mr. Keefe apparently solicited some of Cross's customers? I mean, there is some evidence in the record suggesting that.
I think it's true that there is some evidence in the record suggesting solicitation, but the non-solicitation provision itself needs to be valid in order for there to be a breach of that provision. The non-solicitation provision, we've been talking a lot about the non-competition provision, the non-solicitation provision is overbroad too, because that prohibits Mr. Keefe from soliciting any of Cross's past, current, and prospective customers, regardless of whether or not Mr. Keefe talked to that customer or had knowledge of that customer. Typically, these provisions limit the solicitation to those customers with whom the employee had contact with or had confidential information about.
Counsel, on that point, this just may be my ignorance in not understanding how these sales positions work.
Sure.
But I had to notice some tension between the inability of Mr. Keefe to access purported proprietary information like a customer list, and then his contractual obligation to not solicit folks. And how would he know who not to solicit unless he had access to the customer list that's supposedly a trade secret? Can you help me understand that?
Sure, and that reminded me, if I could just briefly, you asked a question about whether or not Mr. Keefe, the information that he downloaded included the information from I-360 or if it was just customer proposals. I-360 was a different database. Mr. Keefe retained, which was not prohibited under his agreement from downloading this information, he retained his customer proposals. So he did not have access to Cross's full customer list. So he had access to his own customer proposals, but there's 14 other sales inspectors, or I think Mr. Miles testified 15 or 16 at the time total. There's 15, let's just call it 15 other sales inspectors at that time. There's also testimony that they would do between 300 and 400 leads a year. So I have the map in here somewhere, but assuming it's 15 and a couple hundred, I mean, we're talking over 10,000 potential customers in the past 2 years, many of which, 14/15 of which, he wouldn't have no access to information about those.
So what was on the USB drive?
Customer proposals.
And only his?
His historic customer proposals.
Okay.
And it's in the record that the reason why he did this is because he wasn't sure that he'd be paid his commissions.
Okay, so no other proposals, but his own proposals were on this USB drive that,
Correct.
where, I don't even know where the USB drive it is.
Correct, and, right. But I think it's important to point out here, and this ties into the confidential information and trade secrets piece, is his agreement does not prohibit him from downloading this information during his employment. It only prohibits disclosing the information to others, and importantly, the agreement does not have a return of property provision. It doesn't require him, upon separation, to return this information. So to the extent that they're arguing that customer lists, even customer lists, that customer lists and customer proposals and customer lead information are confidential, they know that these sales reps had them on their phones, they would download them, they'd print them out, and they'd bring them to proposals. They would have them to customer meetings. They'd have them in their cars. If this information is so confidential, they should have put a return of property provision, which is standard in employment agreements, saying, when you leave, you need to turn over all of our confidential information, and you can't retain it
But
post-employment.
these proposals that he downloaded, these were all proposals that had been given out to customers, disclosed to customers?
I believe so. There may be some drafts that may not have been. I don't know. But they were his customer proposals that he would have, you only generate a customer proposal when the sales inspector goes to the customer's house or business and they give them, I want waterproofing and here are the measurements. So Mr. Keefe would input the measurements and then the proposal.
But once you give out a proposal, it's no longer confidential.
That's
Because
correct.
the customer can share it with others.
I would say it's no longer confidential. And it certainly, if it's not confidential, it doesn't meet the requirements of a trade secret. Because once that's disclosed to customers without any sort of requirement that they maintain the confidentiality, then it can't be a trade secret.
So there were Let me make sure I'm understanding.
Sure.
There was no actual list. There was no document with proprietary pricing information. It was simply proposals? Is that?
It was customer proposals and customer contact information. Those are the two things that Cross has repeatedly said in their briefing constitutes both the confidential information to serve as the legitimate business interest for the agreement and the two items that serve as the basis of the protectable trade secret.
And customers, the customer contact information, were these customers that he also did not deal with that other salespeople dealt with, or were these only his customers that he had dealt with?
His customers.
Only his customers.
Yeah, he did not have a customer list. He did not have Cross's master customer list, which is generally the type of information that you see misappropriated in these cases. You know, a master customer list with customer contact information, historical pricing information, historical purchasing information. That's the type of customer list that can rise to the level of confidential information or trade secret because a company has invested substantial time and effort and years and work into developing that customer list. Here, it's just his proposals, and the customer contact information is on the proposals. And
So
customers.
it's not separate. So the customer, when we're talking about customer contact information, it's on the proposals that were handed to the customers.
Yes, but he also maintained that information on his phone. He used his personal phone for work, and so when he left, he didn't have to turn it over. They didn't tell him to delete customer information, so he still had customer contact information on his phone.
They knew he was using it too.
Correct.
I mean, they didn't like it, apparently, according to.
He was told not to?
He was told not to, but he still did it. He wasn't disciplined. He wasn't terminated when they figured out that he was still using it. And then after they knew that he was still using it and he resigned, they didn't say anything. They didn't say, you need to turn this over, you need to.
Counsel, wasn't some of this information, the customer contact information, just publicly available? I noticed in the summary judgment record an email exchange with a realtor, for example, and the realtor's signature block clearly has the realtor's phone number. I mean, wouldn't Mr. Keefe have been able to get these phone numbers from other sources?
Yes, and realistically, customers will go and they'll get several proposals from different companies, all of the same information all the competitors have. They share these proposals. It's information that is out there. And it's important to note this isn't, and we go into great detail in our briefing about this, this isn't a scenario where you have a lot of repeat customers, and the customer identity is really important because you might not necessarily know what this company's requirements are for this type of work, and do they require a multi-year project? I mean, you would hope you only waterproof your basement once.
Yeah, but you could have different, like, let's say that, you know, the front end of your house, the foundation crumbled, and then like 10 years later, the back end of your house. So it's not like it's not
Not
possible.
impossible. Not impossible. But it's not the type of customer relationship that you generally see, that you typically see serving as a legitimate business interest, like to protect that goodwill. Because that is a developed customer relationship over a number of years where you have information about that customer that would benefit your competitors if it's in their hands.
But in some cases, it was like with the Northern Kentucky University account, it's obviously a bunch of different buildings.
Sure, and I think that that's the exception. I think the record is clear that there are some examples of repeat customers, but as a whole, this industry is more aligned to.
Counsel, this is a really minute point. But if we accept that NKU, for example, is a repeat customer that Cross would want to protect, I noticed that it looked like NKU was coming back for services about every 2 years. Would a 1-year agreement protect the business interest of Cross in that circumstance?
So I think that's why these analysis of non-compete cases are so fact-specific, because he had thousands of customers, and they were only able to point to a handful of repeat customers that would pose somewhat of a competitive, or that would serve to justify such a broad restriction on his future employment. So I think, you can certainly comb through the record and find one or two that would justify a 1 or 2 year restriction, depending on the business needs. But the point is that Cross is asking the court to do that work. And
these repeaters are coming back over a longer period of time. And so would a shorter agreement really protect them? Wouldn't they need a much longer agreement, and then that starts to look less reasonable?
It certainly would look less reasonable. And I think that another interesting point that was raised just a few minutes ago is the temporal scope issue and where we are now 2 years later. And procedurally, they moved for a PI and then they canceled the hearing. They withdrew the PI. So now we're 2 years down the line. They have not moved for an injunction, and now they're asking this court to assert, not this court necessarily, but they're focusing on the liquidated damages provision, which has its own issues. And you also heard about the $66,000 in damages that they are able to now point to. That is something that came up in discovery responses, supplemental responses, 2 months after discovery closed, and 2 months after Mr. Miles testified that he can't name a single, sorry, missed the yellow.
You can wrap up.
He couldn't name a single customer or point to a single document that showed any financial loss by Cross.
I do have one question about the damages. So to me, the contract reads in lieu of. So if they were able to prove actual damages, would that be the end of it, or would they also still then be entitled to liquidated damages?
I don't think they would be entitled to liquidated damages at all. And to allow liquidated damages in this situation would mean that that employers are going to have employees sign overbroad non-compete agreements, hope that a court will reform, or mandate that the court reform them, tack on a liquidated damages provision, and then hope that an employee is deterred from looking for greener pastures, or hope that an employee doesn't have the money to wage a years-long legal battle. So allowing, lots to talk about in terms of the liquidated damages provision, but I think allowing a liquidated damages provision for an admittedly overbroad agreement and saying I'm only pursuing liquidated damages would set some bad precedent.
Thank you. Mr. Yocum, you have 2 minutes.
Thank you, Your Honor. Very quickly, I'll finish my citation there on the liquidated damages. The case I was referencing, Security Fence Group versus City of Cincinnati, is a First District Court of Appeals C020827. That's a 2003 Ohio 5263. And I'm familiar with that case because I mentioned I was involved, and the Court of Appeals at that time made it very clear, the holding in that case, that proof of actual damage is not required to enforce a liquidated damages provision. And that's the law well established by the Ohio Supreme Court and other Court of Appeals across Ohio.
Counsel, in that case, was the language of the liquidated damages provision the same as this one, where it said in lieu of?
I don't recall if that exact phrase was used in there, but in the other case I mentioned, the physician's anesthesia case, that case dealt specifically with an employment agreement decided by this Court of Appeals upholding a liquidated damages provision in a case involving a nurse and her employer. So but I agree with what you're saying. It's one or the other. We're saying that liquidated damages is the most appropriate, and that's what was provided in the agreement because of the difficulty in proving actual damages in these type of cases.
Are you able to prove? I know 66,000 was thrown out as a figure. Are you able to prove?
There is proof of that is in the record, and we think more, probably much more. But it's difficult to prove, and that's the reason that liquidated damages provision, and this is discussed in multiple cases across Ohio, that's the reason for LD provisions in these type of agreements. Now, you're moving on, I'd like to...
Mr. Yocum, you have about 10 seconds.
Raymond, let me read syllabus 1. It says, a covenant not to compete which imposes unreasonable restrictions upon employee will be enforced to the extent necessary to protect the employer's legitimate interests. We think it's required. The trial court did not do that.
Right. Thank you. Thank you for coming today, and we will issue a timely decision.